Calling the case of the people of the state of Michigan versus Felicia Sherwood Bovee, file 210774FY. Counsel, identify yourselves for the record, please.
Joseph Damon on behalf of the people, Your Honor.
Thank you, Your Honor. Chad Dieter appearing on behalf of Ms. Felicia Bovee.
All right, today's time and date set for a second probable cause conference. Mr. Diedrich, have you talked with your client and the prosecutor, made a decision regarding the preliminary examination? Not able to hear you, Mr. Diedrich.
Can you hear me, sir?
No.
Can you hear me now?
I can.
All right, I'm sorry. We've been having problems with this all day today, apparently. But well, Your Honor, where we're at, there's a current offer of no contest. My understanding, no contest would be okay to an aggravated assault, no additional charges, and forfeit the firearm. I did inquire about a Briggs-Killebrew agreement. The prosecutor is not willing to offer into one, and my client has requested that I discuss a possible Cobb's agreement.
We lost Mr. Diedrich.
Hello.
All right. We typically don't do that, Mr. Diedrich, because we have so many cases and running them. There's a difference when you have fewer cases and multiple Department of Corrections officers who can look into and provide background and information in order to make a determination for the judge. And so I don't engage in that because I don't want that practice to continue. I do take a look at each case based upon the person's criminal history, their compliance with the seriousness of the charged, as well as what they pled to. And then I also take a look at how well they've done in pretrial services. And your client has no prior criminal history, so that's working for her. It gets reduced down from a felony to a misdemeanor. That would work for her, and I presume she's working on pretrial services. So most of the time that results in almost exclusively probation. However, I don't know much about the facts of the case, and I don't know the extent to which the victim might provide information. So I don't know if that helps you or doesn't help you.
Your Honor, would it be possible to have a brief breakout room with Ms. Bovee?
You certainly can. We'll put you in a breakout room so you have an opportunity to talk with your client.
Thank you, Your Honor.
You're welcome. Diedrich, have you had an opportunity to discuss the matter with your client?
I have, Your Honor, and she wishes to avail herself to the prosecutor's office. And I guess I just need confirmation. I did have an email that confirmed no contest plea would be acceptable to the prosecutor to the aggravated assault charge.
Any objection to the legal reason for the no contest plea?
Would be limitation of civil liability, Your Honor.
Okay. Mr. Amon, do the people have an objection to the no contest plea?
No, Your Honor. The full agreement, she could plead no contest for purposes of civil liability to aggravated assault, the 1-year misdemeanor, being no additional charges, and she'd be required to turn over and forfeit the weapon. The felonious assault charge would be dismissed, but for purposes of the factual basis for the no contest plea, we would take the factual basis to the felonious assault.
Okay. And is the firearm in police custody at the time?
No, it is not, Your Honor. She'd have to turn it over to the police before sentencing.
Okay. I guess that would be the understanding. Is that your understanding, Mr. Diedrich?
It is, Your Honor, and I guess if I could just fully disclose the situation, the court mentioned pretrial services, and I'm not sure that Ms. Bovey had been enrolled in pretrial services because she was just informed to go do her fingerprints, if my recollection serves me right.
She may not have. What we'll probably do is just get a PSI done. I have the affidavit that I could use to swear out that was used to swear out the complaint that I could use as factual basis. Any objection to me using that, Mr. Diedrich?
No, Your Honor.
Okay. All right. May I address your client?
Yes, Your Honor.
All right. Good afternoon, ma'am.
Good afternoon.
Your attorney has said that you're planning on entering a no contest plea. No contest plea is you saying, I'm not saying I did it. I'm not saying I didn't do it, but I'm willing to accept responsibility for it. And it's a no contest plea to an aggravated assault. That's a reduced charge from a felonious assault. Felonious assault is using some type of, in this case, a firearm to scare someone. And so what would happen is I would take a factual basis based upon what the affidavit that was presented to the court. Do you understand the offer, and are you planning on following your attorney's advice who said you should plead to the charge?
Yes, sir.
Okay. If you would raise your right hand and be sworn in. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right. You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No.
Are you under the influence of any medicine, drugs, or alcohol that's confusing you at the moment?
No.
If you enter this plea, you'll be waiving the right to trial. You could have had a trial of the original charge by jury, or if you, your lawyer, and the prosecutor agreed, it could have been a bench trial, but there'll be no trial at all. Do you understand that?
Yes.
You'll be waiving the right to request a court-appointed attorney or represent yourself. Mr. Diedrich is your attorney and will be your attorney for this case. Do you understand that?
Yes.
You'll be waiving the right to remain silent and not have your silence used against you, and the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand this?
Yes.
And you'll be waiving the right to confront your accusers, call witnesses, and testify. Do you understand this?
Yes.
Waiving your rights and understanding them are different. I think you do understand your rights. You would have to waive these rights in order for me to take this plea. Do you waive these rights?
Yes.
How do you plead to an added count 2 of aggravated assault, which is a misdemeanor punishable by up to 1 year in jail? That doesn't mean that's what you'll get. I just never told you what the maximum penalty was. How do you plead to that charge? Do you plead guilty, not guilty, or stand mute, or as your attorney recommends, no contest?
No contest.
Mr. Diedrich, I'm going to show on the computer screen a copy of the affidavit so everyone can see the information that I'm using. Here, let's see, it should be up there by now. The affidavit indicates that on or about May 12th, 2020, in an address on North Bradford in Lee Township, that there was a felonious assault complaint. There was a vehicle stopped in front of a residence. The victim approached the vehicle. Suspect then exited the car and pointed a black handgun at the victim, stating she was going to shoot him. Victim believes suspect's daughter was in the vehicle. He heard her state that's not the guy. Suspect lowered the gun and left the scene. Victim thinks the suspect believes he assaulted her daughter last year. Suspect questioned and denied the incident. If I use that information, Mr. Diedrich, and I believe that it actually happened and it was true, would I have factual basis for the underlying charge or the original charge for felonious assault, and therefore enough for the aggravated assault?
Yes, you would, Your Honor.
And Mr. Amon, the same questions to you, sir.
Yes, Your Honor.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately will enter in as an aggravated assault. The original charge of felonious assault will be dismissed. We'll set this over for a pre-sentence investigation. And so I don't know, Mr. Diedrich, if you have your client doing any type of counseling or anything that way, but my staff will be in touch to see. Based upon these facts, though I do not like self-help, I certainly can understand there might be some underlying issues that make this more complex than what would it seem at the outset. And I feel more comfortable in my assessment that this is probably more of a probation case and one that we need to make sure that the defendant understands that if there is a problem, that she should seek help from police as opposed to self-help. I did not remember the facts prior to this, but based upon these, I feel more confident that barring your client doing something illegal, foolish, or stupid, that she would receive probation as opposed to jail for this event. I do need to still hear from the victim. However, when I take a look at what he said, his own statements felt like it was a mother trying to protect or make something right with regarding her daughter. And he wasn't pointed out except for the fact of a misidentification. But I do leave open the opportunity for the victim to appear. So, sentencing date and time, Katrina?
Your Honor, that would be September 13th at 9:15.
September 13th at 9:15. Mr. Diedrich, we don't have a whole lot of time between now and then, and as opposed to just ordering pretrial services, whatever was already in place, she's not violating any bond terms. May I direct your client to advise her as to what would be in her best interest between now and then?
Absolutely, yes, Your Honor.
All right. Ms. Sherwood-Bovee, I don't know you. This is probably the first time that I've ever interacted with you, and I don't know anything about the facts of the case. My probation staff, they're going to write a report up after talking with you. Or like anyone else, you're probably going to say that I'm not a risk, but how would I know that? It's better for me to have somebody else say that you're not a risk. You've hired Mr. Diedrich to do that, and he will. But if you get somebody else that takes a look at and gets an assessment, somebody like a counselor, and says, you know what, this is a one bad day, as opposed to this is a person we have to worry about walking around pointing guns at people because she just gets mad and does that, that probably is something that would be helpful for me to know a little bit more about you. That can be done at a counselor. If you're involved in counseling, that can be done. J&A Counseling Services can have a meeting. My whole goal is to try to figure out how do we prevent a similar circumstance from happening in the future. You're going to tell me that you won't do it again. Mr. Diedrich's going to tell me that you probably won't do it again. Your criminal history says you don't have prior history, but I think if you follow your attorney's advice and seek some type of assessment to make sure that we understand that you're not just a hothead with a gun, that would be helpful. Maybe you are a hothead with a gun and we got to get you some counseling. I don't know the answer to that, but you're not going to get the benefit of all this unless you turn the firearm into the police. I probably would call them ahead of time because it makes the police a little nervous when people walk into law enforcement center with a firearm. So you might want to call the police to ask them how to make that happen, or talk with Mr. Diedrich how to make that happen, because it's a requirement, but it does make people nervous when you walk into law enforcement center with a firearm. So work with your attorney to figure out how to make that happen, but that firearm needs to be turned in because it's going to be forfeited, which means they're going to destroy it. Do you understand?
Yes.
All right. Anything further we need to place on the record, Mr. Amon?
Oh, Your Honor, I will call the Sheriff's Department and give, I don't know if it's Lieutenant or Captain Gilbo, I don't know his title right now, but Captain Gilbo a heads up as to they will be receiving contact from Mr. Diedrich or Ms. Sherwood-Bovee to turn the firearm in.
Yeah, they may want to come out to her. I don't know. We'll leave it up to the
Yep.
police to figure out the best way to make that
Yep.
happen.
And that's
Or
why I'll leave it
maybe
up to
Mr.
them, but I'll just give them a heads up that she'll be calling and then they can arrange it.
But realize that that is a part of the agreement. So therefore, if it's not forfeited, then I'm going to withdraw the plea and you go back to having a felony charge.
Okay.
Okay. Anything further, Mr. Diedrich?
No, Your Honor, thank you.
Thank you. We'll be adjourned.
Your Honor.